Good day. I'm Jano Fourie. I'm a legal advisor at the SEESA Consumer Protection and Property Department based in Cape Town.
Good day. My name is Mariam Allie. I'm a legal advisor at SEESA in the Consumer Protection and Property Department, also based in Cape Town. Today's topic relates to the responsibility to disclose warnings and instructions in terms of Section 49 and Section 58 of the Consumer Protection Act, as well as the legal consequences of non-compliance. Jano, could you please set out what the legal requirements are?
Thank you for the introduction, Mariam. Section 49 of the Consumer Protection Act states that in the event that you supply any goods or products that can either be hazardous, dangerous, or has inherent risk that the ordinary alert consumer could not know about, that those possible risks or those possible dangers needs to be explained to the consumer by way of instructions, by way of warnings in a plain understandable language. Section 58 then furthermore state that not only should the possible risks or dangers be explained to the client or the consumer in a plain understandable language, but furthermore, if the product are supplied with instruction manual, that such instruction manual should be supplied with the product to the consumer. Now, the way that this information needs to be displayed in terms of Section 22 is in a plain understandable language which an audio alert consumer will be able to understand, pertaining to the use of words, illustrations, and sentence structure.
Thank you for setting that out so clearly, Jano. So the supplier, should they fail to meet those requirements and a consumer suffers harm as a result of that non-disclosure, the consumer could possibly have a claim for damages. The claim for damages is based on any injury, hospitalization, death, and even includes economic losses suffered by the consumer, such as loss of income. The prescription period is 3 years, which means that the consumer has 3 years within which to institute a claim for damages. Now, the claim for damages can be instituted against any party in the supply chain, which includes the manufacturer, the distributor, the importer, and in instances even includes the installer of those goods. However, all hope is not lost. There are remedies available to the parties in the supply chain. Jano, could you please set out what those are?
Thank you, Mariam. As you stated, as with any other piece of legislation, there will also be exclusions. So cases where the consumer's right to claim damages will be limited, or the supplier's risk will be limited. Now, in this case, there is 2 specific and also 2 general exclusions. The first specific exclusion relates to an importer or a producer providing the necessary warning instruction on the product being supplied, but then another party in the supply chain, let's say a retailer or the installer, repackage the goods. If that retailer or installer didn't provide the same warning instructions or in a similar way, you can't really hold the manufacturer or the importer liable because they did adhere to the Act. Furthermore, also excluded would be a case where a retailer or an installer, taken into regard to a specific place in the supply chain, could not reasonably know or understand the possible risks pertaining to the product being supplied, and therefore didn't have the responsibility to provide it to a consumer. For instance, a person who sells motor vehicle parts. Sometimes they are not knowledgeable about the possible risk of the product being supplied, and therefore they can't really be held liable. Also excluded generally is a case where the consumer had been supplied with warning instructions but decided to accept the product knowing about the possible risk or dangers of the product being supplied, or in terms of public regulations, the product needs to be supplied in a specific condition.
Thank you, Jano. Suppliers should therefore note the importance of Section 49 and Section 58. Should they fail to disclose those warnings and instructions, not only could they be held liable for damages, however, they could also be fined in terms of the Consumer Protection Act. Fines are up to 1 million rand or 10% of their annual turnover, whichever sum is greater. So suppliers beware.
Thank you, Mariam. That is all that we have time for today.